Yes, Assalamu alaikum everyone. I hope this isn't too loud. So yeah, there are some interesting updates in case law in Pakistan on international arbitration. Earlier, Justice Jawad Hassan referred to the Supreme Court decision in the Orient Power case. And as I was planning to speak about that, just yesterday, there was another case that I was involved in counsel for. The Lahore High Court fixed the announcement of a judgment, and I'm pleased to say that I've secured that judgment in favor of my client. But why that case is interesting is because it involved parallel arbitration and court proceedings. So in that case, what had happened was that the defendant in the arbitration matter had preempted the arbitration and filed a civil suit in the local courts. The claimant, obviously, as is provided under the 2011 Act, which implements the New York Convention, filed an application to stay those local proceedings and to refer the parties to arbitration. Simultaneously, the claimant also served a notice of arbitration under the SEAC rules and commenced arbitration in Singapore. The arbitration proceeded. The defendant was of the view that the arbitration should be stayed till the civil court has had an opportunity to decide on the validity of the arbitration agreement. Obviously, if he was successful in proving that there was no arbitration agreement, then the entire arbitral process would be obsolete and it would be a waste. However, the tribunal in Singapore decided that it was not obligated to stay its own proceedings because the arbitration was governed by the procedural law of Singapore. That's what the parties had chosen by virtue of designating the legal place of the arbitration to be Singapore. The defendant chose not to participate. The defendant did raise jurisdictional objections, but then chose not to participate on the merits, and an award in favor of the claimant ensued. The claimant then obviously filed an application before the High Court seeking to enforce the award. The defendant raised objections under Article 5 of the New York Convention, requesting the court to refuse enforcement on three main grounds. The first was, or the first two, which are sort of interrelated, was that the defendant was incapacitated or was unable to present its case before the tribunal simply because there was a pending application before the civil court. And then its last third ground was that the decision of the tribunal not to wait for the civil court rendered the award against public policy. The Lahore High Court rejected all three grounds and enforced the award and confirmed the pro-arbitration bias of the High Court or the courts in Pakistan. The court clarified that if you decide yourself not to participate simply because you have filed parallel proceedings in a local court, then that's on you. You don't get to make that as an excuse for not participating. Second, the importance of the judgment to me is that it confirms the seat theory. That was something that Justice Jawad also alluded to in the Rupali judgment back in 1998. The Supreme Court recognized the seat theory in that it is only the courts at the legal place of the arbitration which have supervisory jurisdiction. And so whether or not an arbitration will proceed, that is up to the courts which have supervisory jurisdiction, And in this case, it was not up to the Lahore Civil Court to decide whether the tribunal should be stayed or go ahead. And the mere fact that an application was pending, which actually took a number of years to be decided, could not be the reason why arbitration would be stayed, because the purpose of arbitration is to actually avoid the trappings of the courts of some jurisdiction. So that was an interesting case, and I believe it really developed the law in Pakistan regarding international arbitration.
Now, Sami, that case then, of course, just gives a neat illustration, doesn't it, of the typical problems that you face in an international arbitration. The usual problems of preliminary points being taken, of non-participating parties, arguments about where the seat was and what its impact is. These are, of course, matters that require detailed training and knowledge. It's not the sort of thing that you can rock up and argue without having adequate training, which leads me to the next point. Could you just give us some ideas as to the sort of ways in which we can improve arbitration practices in Pakistan?
So, I think the establishment of the Pakistani branch of the CIRB in Pakistan is a big step. This branch will obviously provide all the facilities and the materials in order to enhance people's knowledge on international arbitration. But I think it is also very important for the government and, for that matter, the courts, especially the high courts, which have the power to make rules of procedure, which govern their own procedure and the procedure of the civil courts, to use that rulemaking power to provide guidelines on how cases related to international arbitration should be decided. And these are basic issues, like in the previous discussion, a number of questions were raised about how it takes 8 years to enforce an award. Well, frankly, one of the reasons for that is because of the court procedure. Any practitioner will tell you that about 80 to 90% of a high court judge's caseload is all dealing with administrative issues as part of the entire life of a particular case, and has much less to do with actually hearing a case on the merits or hearing arguments. So not only educating all stakeholders on arbitration, but also fine-tuning the judicial process, which plays a huge role in supporting arbitration.
That's very helpful. I think there's just one last point, and I probably just need your agreement on this or not. Do you think Pakistan needs to adopt the model law? And it's a yes, no, and if either which way, a short explanation.
Very short explanation, and absolutely a yes. And this touches upon just a brief point about what law we have in Pakistan on international arbitration. Contrary to popular belief, we do not have any law on international arbitration in Pakistan. What we do have is a law limited in scope relating to foreign arbitral awards and their enforcement, and arbitration agreements which may result in a foreign arbitral award. That misses the entire arbitral process itself, and the adoption of the model law, amongst its many benefits, will allow arbitrations conducted in Pakistan to also be characterized as an international arbitration. It will allow the courts to support it properly, and it will also allow any award ensuing from such an arbitration to be treated as a foreign award and enforced up to those standards.